And you can go ahead and start, Judge. Thank you all for joining us today.
Thank you, Ms. Hubbard. Thank you for everyone who's on the Zoom today. And I do want to thank the New Mexico Family Advocacy Program for inviting me to present, and also for the great work that all of you are doing to improve the lot of children and their families. I do want to also thank the members of the Enhanced Family Supports Work Group, specifically for the work on enhanced family time. They've put a lot of time and effort over long hours in developing what we've been able to do thus far. It's still a work in progress. We continue to work. And thank you to the Children's Court Improvement Commission leadership for establishing the Enhanced Family Supports Work Group, and for considering what we've proposed, and for allowing us to move forward with the things that we've developed thus far. A little bit of background about the Enhanced Family Supports Work Group. We of course know that the Children's Court Improvement Commission has a strategic plan. I don't remember what year they're in right now, but sometime around the fall or winter of 2020, a proposal was submitted to the Children's Court Improvement Commission on enhanced supports to families. The focus nationally, and certainly in New Mexico, is turning toward a very important part of child welfare work, and that's supporting families instead of criminalizing them or putting them in a negative note. And that is a work in progress, not only in New Mexico, but nationally. Part of the enhanced supports to families included the notion of how do we get to permanency sooner rather than later? How do we reduce children's time in foster care if we provide enhanced supports to families, with the goal, which is generally always the initial permanency plan goal, of reunification? And in doing so, what part does family time, what we've always called visitation, but what part does family time play in that goal? And how do we make it happen sooner rather than later? And how do we ensure that it is included in a case plan and that is part of the children's permanency plan? So a number of values that the Enhanced Family Supports Work Group worked on was, what do we believe and how do we work for this based on what we know and what we've done by reviewing the research and other states' practices. Well, one of the values is that family time is not a privilege, it's a fundamental right, certainly for the children and youth who are in out-of-home placement, and certainly for their parents as well. And we've learned that more family time results in shorter time in out-of-home care. That's a well-established research finding. But back in the fall and winter of 2020, COVID was in full bloom. The vaccines had still not started being injected and so forth, and things look pretty gloomy in terms of face-to-face, in-person contact between children and out-of-home care with their families. And in some jurisdictions, and because of limitations, not only for the system, but for inability to access virtual resources, there was very little family time or visitation going on between families and their kids who were in out-of-home care. So the Children's Court Improvement Commission placed a great sense of urgency on this initiative, that we needed to work on this and come up with a plan. And of course, we know that even though we're in 2022, COVID, monkeypox, and all these other things are still looming, and we shouldn't sit back and say, it's over, we can start doing things back to normal, whatever that is nowadays. So the Children's Court Improvement Commission took the following action. They established the Enhanced Family Supports Work Group, and we were charged with taking on a number of tasks. Among those tasks was, very importantly, taking a look at what the federal government, particularly the Administration of Children and Families and the Children's Bureau, viewed as an important consideration when it came to family time. That information is contained in the Children's Bureau Information Memorandum that's noted in the first bullet point. I believe it is available to you through the NMFAP directory or resource of information that they have. I would encourage you to look at that. It contains a lot of research information and the sites to that information. So if you think I'm making some of this stuff up, look at that. Also, the Casey Family Programs publication that should be available to you as well. That includes much of the same research information, as well as additional things that we all need to be considering. So in addition to reviewing that information memorandum, the Children's Court Improvement Commission charged us with looking at what other states are doing, not just the research, but what other states are doing and engaging in as best practices or things that they're working out to see if they are best practices that have to do with providing meaningful family time or parent time as they call it in Nebraska. One of the very in-depth things that was done with, and I'll present a slide in a moment of who made up the work group, but certainly much of the information coming from line workers from the Children, Youth and Families Department, as well as those in policy positions, to help us review what was current, what is currently the policy in New Mexico, what's happening in New Mexico, not just with regard to family time or visitation, but how is this dealt with in case plans? What's the frequency and quality of family time? Where is it taking place? Is it in the least restrictive environment or an environment that doesn't resemble a family setting at all? And for siblings who are not placed together, what kind of family time is occurring between siblings? And I would also say, pets are important to many of the kids who are removed from their homes, and what is being taken into consideration as far as listening to kids who say, I want to see my dog or my cat, or at least I want to know what's going on with them. And very importantly, we were charged with seeking input from those with expertise in their experiences, families and youth and children who were impacted by family separation and from maybe not having any family time at all, maybe not being heard, and just being told what to do rather than ask what's going to work for you. What did they see as barriers to good family time visitation? Youth and parents with lived expertise are included in the work group. So are resource parents. Court-appointed special advocates are represented by members of the work group. And as I've already indicated, both policy folks and in the trenches folks with CYFD are included in the work group. And parents and children attorneys, the GAL youth attorneys, and of course, parent attorneys and judges and hearing officers are represented in the work group, those who have put in their time and effort and expertise into moving in the direction of how does enhanced family time relate to reduced time in out-of-home care and promotes safe and lasting reunification. As noted previously, the Children's Court Improvement Commission tasked the work group with looking at research and also model policies in other jurisdictions. In Georgia, since about 2004, they began meeting together and including a whole host of folks statewide in developing what came to be known as a family time practice guide. And I don't recall if it's in the information memorandum from the Children's Bureau or in the Casey Foundation document, or both, but there's a link there to that entire 82-page Georgia Family Practice Guide. Very in-depth, very detailed study of what they're trying to implement in Georgia. And I have to say, it's not all rosy and positive. Anytime change comes about, a lot of work needs to be put into bringing about what has been developed. Nebraska was another state we briefly looked at in what they came up with as guidelines for parenting time. The same basic premises of, more family time reduces the time the children are in out-of-home care because it leads to permanency sooner rather than later, whether it's reunification or some other permanency goal. The work group also took into consideration the Quality Parent Initiative. Admittedly, we haven't been able to spend as much time on that as we want, but we understand and accept the fact that the Quality Parenting Initiative is not just for the children's parents, but for their short-term parents, the resource parents, the foster parents, and promotes all sets of parents working together with the children to improve the outcomes for the families and the children, whatever permanency ends up being. After considering many factors that were presented to the group by CYFD and by all of the other participants in the work group, those who had experienced the child welfare system, good, bad, or otherwise, this is what was agreed as the current purposes of visitation. Not that it's easy to admit, but those of us who practice in this area of child welfare would not deny that to some measure, in most cases, this is how visitation family time starts. It starts with negative assumptions, not looking at the positives. Some of the negative assumptions include family time has to be supervised and it has to occur under the watchful eye of the department. The general culture in New Mexico regarding family time is it's very paternalistic. It doesn't give much credit to the families who care more about their kids than we ever could. And that's not denying or overlooking the fact that we all need help. None of us is a perfect parent. The general culture in New Mexico, we also agreed, was that it emphasizes supervision and policing of parents. An attitude of we do what we do to gotcha, to catch you doing something wrong instead of encouraging you and creating an environment that taps into what you already know about your own shortcomings, what you know about your strengths, and very importantly, how well you know your kids, better than any of us could ever know them. And one of the things that the research and practices in other states emphasize is child and family well-being. The general culture in New Mexico, we concluded, includes very little about the relationship between child, parent, and family. And that's not to say that in every case, and it depends a lot on all of you who are attending today, participating today, what level of advocacy you undertake to ensure that family and child well-being is not left on the back burner or not even on the stove at all. So these are some of the research and best practices findings that the work group was able to distill. Things that I think we already knew that were kind of no-brainers that we all know. That the relationship between a parent and child is paramount. We also know that according to ASFA and according to best practices throughout our work in child welfare, that safety of the child is paramount as well. But you can't separate the two. Relationship and safety, I would argue, go hand in hand, as some of this research and best practices reveal. Family time is also critical. No-brainer, as my grandkids would say. Family time is critical to ensuring that there's a parent-child relationship ongoing when the child is not with their parents in their home of origin, but instead is in caring resource families' homes. And it's important that we take the view that we need to protect that parent-child relationship, not do things consciously or unconsciously because it's the way we've always done it, but rather, how do we protect the parent-child relationship? From the time of removal throughout the entire case, we need to ensure that parents are included, that they're encouraged, and that they're supported in continuing to be parents. Some of you may have heard me say in my cases, if we don't include the parents, we're essentially giving them an unwanted vacation from being parents. They need to be involved in parenting activities and decisions like school, like medical care, like any number of things that parents do for their kids. And very importantly, we should not assume that when a child is removed from their home of origin and placed in out-of-home care, that any time for visitation or family time has to be supervised. That's part of the negative culture that was brought out earlier in the work that's being done by the work group. So the National Council of Juvenile Family Court Judges, a shameless plug from yours truly, has worked on an enhanced resource guidelines, and that's a number of years old now, but still a policy statement by an 85-year-old judges organization has this policy statement. And it's not surprising that child safety is a huge consideration. But along with being mindful of child safety, relationships between other family members, including siblings, and I would argue pets as well, because many families have pets and they are considered part of the family, but also among siblings, that relationships are very important. Family time should be liberal, early and often, I would argue, and presumed unsupervised, unless there's a demonstrated safety risk that is articulated, placed on the record, and owned by those who argue that there's a safety risk, so that the court can make a decision based on the information presented as to whether it makes sense to have supervised visitation as opposed to something less restrictive. The National Council also emphasized, as I've said already, that time with brothers and sisters and pets is also important, along with spending time with parents. And when I left the bench, the department had stopped doing this, at least as far as I could tell in the second, but not using family time or visitation as a reward or consequence for a parent who's either working the plan or not working the plan. And because when we use it as a consequence to stop family time, not only are we impacting the parents, we're disincentivizing them, we're also causing harm to the children who aren't getting to see their parents through no fault of the children. So safe, meaningful, and high-frequency family time is a critical component that needs to be taken into consideration if we're concerned, and I think we all are, about removing the trauma of removal and placement in out-of-home care. No matter how good and loving that out-of-home care, how good that resource family is, there's still trauma involved with being removed from your family of origin and placed with people that you don't know. Maybe even placed with people that you have some acquaintance with. You're not with your family. Also, safe, meaningful, and high-frequency family time is critical to maintaining that family, that parent-child relationship. Promoting and maintaining healthy sibling relationships is also important and critically impacted by safe, meaningful, and high-frequency family time, whether it's in place or not. Child and family well-being, one of the things that we considered lacking in the state of what's going on in New Mexico, the current culture. So that's family time early and often is critical to maintaining and promoting child and family well-being. And very importantly, reunification may happen sooner rather than later, or some other form of permanency if we engage in safe, meaningful, and high-frequency family time. If it results in expedited reunification, it also results in positive well-being outcomes for children and their families. So far, the work group has worked on a number of projects. I call them projects. I think, I hate to refer to them as deliverables, but, taking seriously the work that the work group has done, these are some things that the Children's Court Improvement Commission has given their approval to. And a little bit of, a step back, part of the work group strategies were to develop tools and additional training to encourage and promote more active involvement by judicial officers. I have to admit that my colleagues, or certainly I, and I mean colleagues statewide, that very often our role on the bench is a passive one. It needs to be active and engaged, because judges judicial officers and child welfare have a different role than judges do in criminal cases, criminal law cases, civil cases, and we need to be actively involved in asking questions. We were also charged with, part of our strategy in developing tools and promoting additional training like this one today to promote more active advocacy from the attorneys representing parents and the attorneys, guardian ad litem youth attorneys representing children and youth. So these projects are an outgrowth of those strategies. So among the things that we've accomplished thus far, and it's already been disseminated to judges, the Judicial Officer Family Time Visitation Survey. And essentially what that is intended to do is to get judges' input from the place where they sit on what is going on with family time, visitation, what is the judge's role, what do they perceive their role to be. And we're going to spend some time today looking at the other approved outgrowth from the Court Improvement Commission, the draft order on family time. I want to emphasize, and I've underscored, that it's a draft order. It's not in any final form yet. I believe some of the judges in the second have tested it out and are working with us on making it better, making it more responsive. But revisions of the order and use note development is ongoing. Once we come to a place where we can pilot it, we're certainly looking for possible pilot sites where this can be rolled out and utilized to see if it makes any difference. And it'll be a long-term project. We're not going to know that from 1 month or 2 months or even a year's time of using a final order on family time. And again, all stakeholders, attorneys, judges, youth, children, and very importantly, parents and resource families. How do we engage all of these stakeholders in effective family time planning? So we're going to take a look now at the draft order on family time. I'm going to stop sharing my PowerPoint and get the draft order up for us to take a look at. Can everyone see that? State of New Mexico order on family time. So this is, Leslie, is that showing up okay?
No, Judge,
Oh,
we're
we
not
can't
seeing
see it, Judge.
Okay, thank you. Excuse me. So this is an order like most judges and hopefully family members have seen as well when you get a copy of any order from your case. And it's designed in this template that I'm using. It doesn't have any use notes to it, and it's been changed a little bit, but just for purposes of something that can be used by anyone, even parents, maybe especially parents, to take a look at what they ought to be involved and have a voice in the planning for family time. Don't leave it to your attorney to be the decision maker. For those with family advocacy program assistance, they can be real great resources for you in planning this family time as well. And I want to, somewhere in this draft order, it said, or someplace I mentioned that it should start as early as the custody hearing. I would suggest to you that planning for family time starts even before that. From the time the child is removed, it is unconscionable that in many instances, 10 days go by from the time your child is removed in the custody hearing, and children haven't seen their parents and parents haven't seen their children. So advocacy based on this draft order and its contents can be useful even before the custody hearing. So taking a look at the
sorry,
order.
we're still not seeing it.
Oh, I'm sorry. Let me see if I didn't. I don't think I started sharing. That's the problem. Kind of hard to do that if you're not sharing the document. Hang on just a moment. You should see it now.
Got it. Yes, thank you.
All right. So again, a familiar document to many of you. I want to emphasize that this is the use of the proposed order on family time means it needs to be individualized. It needs to take into consideration the specific needs of each child and of each parent. And certainly later on, as we get to the transportation part of it, it needs to take into consideration the resources available for transporting children and the resources available to parents and others who will be involved in family time from getting to one place to the other. So again, a date that the case comes for hearing before the court, and it's this particular order is designed to be for each individual respondent and maybe for each individual child, not just all children and both respondents or custodians and caregivers in one fell swoop. It is an individualized order on family time to address the specific individualized needs of the respondent and each child, each respondent and each child. So one of the first decisions that should be looked at is this going to be unsupervised family time? And if not, if it's going to be supervised, what are the specific safety considerations that must be placed on the record and included as part of this order for each respondent and for the child or children included in this individual order? So big decision from the very beginning, unsupervised, and if there are any parameters that need to be taken into consideration with unsupervised family time, include those if there are any. Or if it's not going to be unsupervised, check the box supervised and then be prepared to explain and add articulable, evidentiary kinds of facts as to why safety is a concern. And there's only 2 lines on here, but that shouldn't be limitation. You know, you can add as many lines as you want. You can erase all the lines and do, you know, a detailed listing of what the safety concerns are so the judge can take into consideration whether those have merit or not. And they should be, you know, the judge is the one who's going to eventually sign this order, the judge or the special master or the special master and the judge. So they have to decide if this is an order they can put their name on and live with what has been found. So if it's going to be supervised, the order provides for changing those visits to unsupervised if that particular parent does X, Y, and Z. Again, that's kind of, you know, gives the parents something to look to and say, okay, I'm going to do those things, and the visits can be changed to unsupervised. May doesn't mean it shall, but may be changed if I do these things. If the visits are going to be supervised, the family time is going to be supervised, there's an agreement you can reach as to who's going to be doing the supervision. It doesn't necessarily need to be someone from the department. It can be a visit host. It can be a trusted family member. It can be someone who is classified as fictive kin that everyone agrees can oversee what is going on in the family time to ensure safety and least restrictive environment is what's being is what's going on. And if the department is going to supervise the family time, that box needs to be checked, and an explanation, not just in one line, but why, and what's the level of supervision going to be, and who's going to be supervising. And I recognize who will be supervising may be a fluid situation depending on who's available, but to the extent possible, it should be the same person so that everybody knows what to expect and what is being required of them and what is going on that shouldn't be going on, or what is going on that should get an attaboy and a pat on the back where they look to changing to unsupervised visits. Any questions so far? I can't see the chat box, so if there's anything that folks want to bring up, Leslie, help me address some of those questions that may have come up so far.
Yeah, there is a question. It's from Casey in Sandoval County. I'm curious if in situations when therapists, et cetera, recommend things like therapeutic visits or supervised visits or changes are being requested by parent or the department, will a hearing need to take place to discuss the circumstances? What if parties don't all agree?
we'll talk about later on in the order, but clearly I was always told in no uncertain terms that therapists are a resource. It is up to the department and the court to decide how these things are going to occur. And I was specifically informed by folks in leadership in the department, it is ultimately our call whether what is being recommended by the therapist is something we're going to adhere to. That's not to say therapists shouldn't be minimized and discounted, but if they have a reason that has to do with safety, well-being, or treatment of that young person who is the subject of the family time, that needs to be included as to why only therapeutic visits. And it used to be a frequent request that if the therapists are recommending therapeutic visits only, can they at least be on a Zoom call, or I think on a virtual hearing or on the telephone under oath to put on the record why that's necessary, so the court can make an informed decision about whether therapeutic visits only are to take place. And again, remember, this is an advocacy tool for attorneys, for parents, for those of you who are in the business of supporting and assisting parents. It's an advocacy tool for CASA volunteers. It's an advocacy tool for parents themselves and for youth who want to be heard and have their voices heard on all of these issues. Hope that answers the question, and we'll be moving on to other parts of the order, of the draft order, that may address that. So it should be agreed upon early, and it can be changed, of course, but where is family time going to take place? Identify those locations or the location that the parties have agreed upon, and choice number one, choice number two, choice number three, so that there's not a torpedoed family time session because only one choice was not available. Have a plan B and a plan C. And everybody should be heard on what those location plans should be. How frequently should family time sessions occur? This is something that can be discussed well before and should be discussed. Attorneys with your clients, guardians ad litem with your charges, youth attorneys with the youth that you represent, and certainly parent attorneys with your clients. The department's going to be discussing this with their permanency planning worker and others in coming up with a determination of how frequently family time should occur. One of the practices that we discovered in one of the admonitions was family time should not be held up because of lack of resources by the department or in the community. Family time is that critical that it needs to happen. If resources aren't available, it's important for leadership to take place, whether it's from the bench, from the child welfare department, from the attorneys involved in coming up with new resources. How do we develop them? Y'all are smart folks. Parents are smart folks. What is at stake is maintaining the parent-child relationship. And we all know that kids, regardless of their ages, very often have very strong positions, and they're very smart too. After all, they're the ones that are impacted by the decisions that we allegedly smart adults come up with without including them. So the family time plan should be set in place, hopefully well before the custody hearing. And if not by then, certainly before the adjudicatory hearing. So a determination of the minimum of times per week and the minimum of the amount of time for each visit should be determined. I kind of point you to the Georgia family time practice model because it goes into great detail on ages, birth to 3. What has been determined by research to be optimum family time for a child that age. And we know that for kids of that age, newborns and infants, it's a whole lot different than with teenagers who have other things going on and who have a very strong position about when and where family time should occur. but critical for newborns, 0 to 3, 0 to 5, some would argue that early and often is critical to maintain and continue that parent-child relationship, or to help them develop a better parent-child relationship. We all know that transportation always comes up as an issue. We don't have enough CSAs to transport. CASA can't transport, or they can, but parents cannot, the attorneys that represent kids cannot transport, or can they? Depends on where you are. But transportation, identifying the barriers to transportation and talking about them should happen early and often in developing that family time plan. So once that's been discussed and hopefully agreed upon, or at least presented to the court for determination, this is what the parties have identified. List that. Again, it's good to have a plan A and a plan B. So resources, transportation options for the kids. That necessarily always involves the resource parents. They should have a voice as well. So one of the things we talk about later is, what about the icebreaker? When did that occur? When is it going to be scheduled? That's included in the order as well. Establishing through the Quality Parent Initiative, a working and caring relationship between resource parents and the families of origin, the respondents in the case, is critical. The sooner icebreakers happen and that begins to develop, the better off the kids and the families and everyone involved will be. So item B in transportation, these are the transportation resources for the parent to attend family time. Not just what transportation options for the kids, but what about the parents? Well, they have a bus pass. Well, when are you scheduling family time? When does the bus run? And sometimes life happens and the buses don't run on time. We should not assume another red flag that because a parent doesn't make it to family time and because they don't have a cell phone to call you up and say, I missed the bus or it's not running, that we should assume that parents don't care about spending time with their children. Dig a little deeper, find out why. Don't jump to conclusions. Don't make assumptions. When you look at the word assume, we all know what that means if you listen to your mom and dad. Icebreaker, I talked about that a while ago. I don't need to say any more about why icebreakers are important, but this family time order breaks it down about, was it completed? When will it complete? It'll be completed on whatever time, or maybe only one parent has been involved in the icebreaker. When is the other parent going to be involved in that? And we all know that it's a real luxury when both parents are available at the same time. Dads very often are the ones that don't get identified early on in the case, and we may be 2 months into the case before the children's father or fathers are identified. It's important to get that icebreaker going for them as well. So if it will be completed by maybe as simple as such and such time for this particular respondent, for this parent, if you're dealing with a respondent who has not yet been located or communicated with, I still think it's important to have this family time order at least, discussed for that absent parent who hasn't been engaged with yet or even served. So paragraph D is one of my pet peeves. The parties can stipulate and they can change the family time schedule at any time. However, that stipulation has to be reduced to a proposed stipulated order and presented to the court for the judge's review. And then if the judge finds it appropriate, for that judge's approval and subsequent filing. A different way of stating that is just because all of the parties have stipulated, the judge has a role in the decision-making. Don't exclude the judge, and judges, you shouldn't be excluded from it either. You cannot be a passive observer of what's going on with something as important as family time. Active involvement by the bench is crucial if we are going to fully implement and get the benefits out of enhanced family time. So now, the department may find a need because theoretically, they know more about what's going on with his family and things that have come up in between hearings. And the department may, doesn't say they shall, or that they, that they have unfettered discretion to change it, but they may change the family time schedule on a temporary basis for less than 1 month of consecutive visits. Be sure you define among those involved with family time planning on what a month means. A calendar month or 4 weeks of visits of family time sessions. Make sure you don't leave that for debate later on. And if the department changes the family time schedule as provided for in this paragraph, then they're required to file a notice of the temporary changes that are longer than 2 weeks, but less than 1 month. And then they're required, and by the way, it's not, I don't think that a proposed change of family time is limited to the department. I certainly can envision.
I mean, I know this is actually a good one.
Situations where the guardian ad litem or the use attorney may decide that family time schedule needs to be changed. They too should request that a change be made and file a motion. But if the department is asking that, they have to file the motion within 10 days to request the permanent changes if they're lasting longer than 1 month. So any motion that the department may have requesting permanent changes has to include an explanation. In that affidavit, they should detail the reasons for the change. They need to document in that affidavit that the department has collaborated with the child's parents, the resource parents, and I would argue also with age-appropriate youth and children, even if they're under the age of 14. They need to be involved in the discussion. Their voices need to be heard. Very often we overlook that, and they have very valuable things to continue if we simply ask them. So in the brackets and in italicized is the issue that even in the work group we haven't decided, but we think it's a good idea when a motion is filed, whether it's the department or other advocates in the courtroom, other legal representatives, CASAs, whomever, parents, if your attorney isn't speaking up, when is this motion going to be heard? I need to plan as well. Set a time for the motion to be heard, Your Honor. Or can we have a hearing set by the end of the day or by next week, by tomorrow, so we know when we are going to be coming back to address this very important issue? So this order also stipulates or provides that the department may add additional visits to the schedule. Again, if in doing that, would expect that there would be collaboration with all of the folks we talked about earlier, the child's parents, the resource parents, the attorneys need to know what is being proposed. They may have a reason why additional visits should not occur. The parents may have an additional reason why more visits shouldn't occur. They just got a new job and their boss is not very flexible. And as much as we'd like to have more visits, let's work it out so that I can talk to my boss, my new supervisor, about the flexibility to do that. Paragraph H, nothing in this order stops anybody from filing a motion to address family time. So anyone who's a party to the case may file a motion to address family time, to talk about what is going on, what isn't going on, how things need to be improved, or how their voice needs to be heard in what is taking place. I see a lot more chats added to the chat box, but I can't see what they are. Leslie, when you help me out as to anything I should be addressing.
I actually am not seeing anything new since the last question, except that Anna Marie Luna agreed with you. She said 100% agree with the judge's response to therapist recommendations. So that was the only other thing that I'm seeing anyway in the chat.
Well, I appreciate Anna Marie Luna's confirmation, because I think I may have heard that from her and assorted other folks in policy and county office manager roles and so forth. So thank you for underscoring that, and that it's ultimately the department's responsibility as to what they recommend to the court. and certainly others have the freedom to recommend to the court as well. Depending on what jurisdiction you're in, a special master might be presiding over a hearing. Typically, the special master will propose an order and recommended by the special master, signed off on, and then submitted to the judge, the elected judge to whom the case is assigned, who will review it, may discuss it with the special master, may want to have an additional hearing before they sign off on it and approve it. So again, don't assume things. Once the judge has signed the order, then you can move forward with it. So this is the sum and substance of this draft order. Again, a reminder that it's still a work in progress. It is intended, in my discussion with others, that we should present it to you today so that you can look at it as an advocacy tool. Some of you who are not attorneys may say, what use do I have for an order? Well, there are important things in here that you can use for your own advocacy. As I've already indicated, whether you're a parent, whether you're a youth, whether you're a participant in the family advocacy program who's assisting parents. And again, remember that this is this is intended to be an individualized order for each parent, and maybe for each child or for each parent and the number of children that are in there. You can also modify this to ensure that there's an order on family time between siblings. And one that probably could include things like, Susie wants to make sure she gets to spend time with her dog. Include that in there as well. I mean, I had the privilege of being involved in cases where the guardian ad litem was the strongest advocate for her client wanting to see how her dog was and wanting to spend time with the dog. So don't overlook the fact that there are many individuals, including animals, who are important in the lives of children who are in out-of-home care and are dealing with the trauma that has been inflicted upon them. Unless there are other questions, I'm going to stop sharing here and get back to the PowerPoint, and I will remind myself that I need to screen share again when I get to the PowerPoint. Any final questions before I get out of the draft order?
Before you get to the questions, I do want to remind everyone it is 12:55, 5 minutes till 1. Our session does end at 1:15. Just giving you guys a heads up if you have a 1 o'clock.
Thank you, Ms. Hubbard. And I think you also wanted to remind them of the survey or the survey that was going to be completed before they log off or sometime after they log off.
Yes, thank you for that. Please remember to complete our post-session survey, important for the program's data collection efforts. The link can be found in the chat box. I do believe Corey she posted it earlier, she can post it again. And join us for our next ECHO session, September the 13th, on the topic of parent empowerment, CYFD individual planning process.
Okay, let me see if I can get back to share the screen.
And the order for family time is going to be made available, correct?
I believe that Corey or Ms. Hubbard, if you all can answer that question, I believe it's part of what will be available to the participants.
Yes, that's correct. It's located on our resource library on our website. I'll repost the link, and there you can access all of Judge Romero's presentation materials.
I should have known we already had it, but thank you.
So one of the things that I want to make sure and let you know that I am retired now. Whatever that's supposed to mean. I think once you get this work in your blood, you don't get it out until you've crossed over to another dimension and you're not alive and breathing anymore, at least not alive physically. So in the first slide, my current email address is noted. I'm happy to respond to an email, or if you want to leave a phone number and you want to talk to me, want me to call you back, leave your number and I'll be happy to do so. So we spent a significant amount of time on the draft order on family time, again, underscoring that it's a draft order. If you are in a jurisdiction where you want to raise your hand and stand up and say, I'd like for our jurisdiction to be a pilot site for this draft order for the order on family time once it's finalized. Don't be silent, speak up, be heard. So thank you all for your time, but there's still time for questions if you would like. I'm always thrilled when I'm attending a meeting and we can end 15 minutes early, but I certainly don't want to shortchange you on time that you expected to be on and that you want to make comments or ask additional questions. Comments are okay. Some of you may be feeling, oh, yeah, this looks really good on paper, but in reality, it'll never work because if you have some of those opinions, please feel free to voice them because you shouldn't be unheard if that's how you're feeling. On the other hand, if your feelings are, regardless of what your role is as a stakeholder in this, if you say, well, we've tried that a little bit, something like it, and seeing good results, or I feel more empowered, or I feel more like I have a voice in what's going on, or if you want to say, gee, I wish this tool had been available earlier, I could have used it in a case that I just have it, it's already a TPR. It would have been better if I had that at some other time. Guess while we're waiting, unless someone has a question that you want me to address, I have a couple of my own observations. Go ahead.
So Judge, somebody did ask, when will this take effect? So if you want to talk about kind of, again, where we're at in this process and, how long do we expect there to be a pilot? How long do we expect this to be piloted? And, and then when do we think maybe it will be out generally released? And then there is another question about from Anna Marie. I would like to discuss Region 1 and 2 in protective services to be pilot sites. Who do I reach out to?
So Mary Ann Darkangelis also had her hand up according to what came up on my screen. So let me answer the first question, then to Mary Ann, and then to Anna Marie Luna. It's one of those dreaded lawyer answers. I don't know the answer to your question as to when it'll be available and official. We're working on that, and we're working on it as a very high priority because we want to get it out and start getting some feedback on it. I think one of the things that I mentioned early on, this is one of those things that's going to involve, data gathering, data analysis, and it's going to take more than just a few months to get any meaningful results that inform whether this makes any sense or not in New Mexico. So be patient with us. Once it is ready, I'm sure that it will be out in some notice form, and we'll make sure that the Children's Court Improvement Commission, hopefully you have representatives on the commission who will make sure and get that information out to you. But we're working diligently as a work group to fine tune it and then identify willing pilot sites so that we can start that aspect of developing a useful tool that will inform us whether, based on data collected, is working or not. Not a very good answer, but the best one I can give you right now. Ms. Darkangelis, if you want to unmute and ask the question, since I don't think you put anything in chat.
Hi, Judge. Let me just say it's wonderful to see you. You're looking very well, and it's an honor to have you share your wisdom with us as always.
Thank you, Mary Ann. Retirement does wonders for your well-being. I highly recommend it.
Well, in my next life. But anyway, so I just wanted to say, I'm ancient in this business, but for years, visits with children were almost used as leverage. Like if you don't work your treatment plan, you're not going to see your kids. And I've seen TPRs go forward. This is quite some time ago with an abyss that had formed for lack of visitation, et cetera, over years. And it just wasn't addressed. So I am and some of the newer attorneys, and I mean by newer attorneys, and I'm thinking of Barry especially, didn't ask if visits were going to happen. He always asked when. That was very interesting to me. So I just want to thank you for not only, really accenting that visits are going to happen, but more detail of the visits, because that was really, I was sitting here thinking how bothered I was in the past about that and could never really make much headway, but it was often really used as a punitive tool. No treatment plan, no visits. And so I am so grateful to see the progress in this area and all the nuances that you have given us today on that order. So thank you very much.
Thank you, Mary Ann. And I, while it was also used as as a punishment, it was also used as an incentive. If you see me in office 4 weeks in a row, maybe we'll consider re-implementing, visits. Again, all of the research that we've been able to find and study, along with what the National Council of Juvenile and Family Court Judges asserts, it should never be used as an incentive or as a consequence, a punishment for whatever else may be going on or not going on in the family plan, in the case plan. So
Yeah,
thank
it
you for
didn't seem
underscoring
infectious.
that. And I do agree that change is coming, and it unfortunately comes slowly, but better slowly than not at all. So thank you for your input. I appreciate that.
Thank you, Judge.
Any other thoughts or comments about what's been presented so far? I don't know if there are any judicial officers on or not. I didn't take the time to look at the participant list as it's up on the screen, or at least that there is a participant list. But a couple of recommendations for judges. I think this is really all about trauma that is inflicted upon parents and children anytime a child is removed. I think, I failed to appreciate that in many of the cases. It wasn't until it was obvious that we had a real serious issue with behavioral health and mental health that I thought, oh my God, it's trauma that's going on here. And who wouldn't be traumatized if your child wasn't removed from your home and you're put in the light of having to be defending yourself, of saying, I'm not a bad parent, or I recognize that I have things that I can improve upon. But family time plans should be actively participated in by the court. And certainly if the court's going to be actively participating in that, so should the attorneys representing parents and the attorneys, the guardians ad litem or the youth attorneys. And certainly the department is involved in that already. But the bench should set very clear expectations about and take into consideration about those plans to ensure that they're individualized, that they meet the specific needs and the circumstances of each individual child and each individual parent. Judges, you should order unsupervised family time unless on the record someone has persuaded you that if it's not supervised, that there are specific safety threats presented to that child. Not only does the judge need to know, but the parents need to know what you're asserting as specific safety threats so they can work on those. So the PPW can also work on those. So the parent attorneys and the family advocacy program folks can work with those parents on those issues. Oops, sorry about that. So the other thing I would add is judges should ask about family time and how it's going at every hearing that takes place. It shouldn't be just at the custody hearing. It shouldn't be just at the dispositional hearing or at the adjudication. So one of the things that has bothered me now, and those of you who practiced before me know that I rarely ever did this. Rarely did I ever get the predisposition report before we went to disposition. It was not unusual that after an adjudicatory hearing, if I found that abuse or neglect had occurred, I would ask the attorneys who were ready to proceed to disposition. Well, there's a critical document that the court has never seen, the predisposition study. And in that predisposition report, if you look at the statute, there's supposed to be an itemization of what family time is going to look like. Visitation, I think the statute calls it. But if I can see that before we go to disposition, I can ask questions about it. If the parent can see that, if the attorney representing the parent, if all of the participants in the case can see that, they're better able to advocate or propose something different if that's something that they want to challenge in the case plan. So I've already said it, but it's important not to assume lack of interest when a parent doesn't show up for family time or is unavailable for family time. Ask why. Asking questions and communicating is very important. Some of the judges heard me state some really somber data about active efforts or reasonable efforts specifically not being found by judges. Even when the department had failed to engage in reasonable efforts, judges still admitted that for a large percentage of the time, they made the finding that active efforts had been made by the department. Advocates, make sure you don't do the same thing. Just blithely accept what the department may be requesting if they haven't done it. If they've done it, bless them to their credit. But if reasonable efforts or active efforts in ICWA cases, if cases have not been made, the court needs to withhold those findings. Not because you want to be mean, nasty, and ugly, and you want to cost the state money, but because it's important in the whole scope of things for families and kids. So I'm going to stop there. And Anna Marie, I don't want to deprive you of your comments. Please go ahead.
No, I'm okay. Actually, I understand that we have some people in the work group and that you all are working on identifying pilots. So I just got really excited about it and want it in all my regions, but they informed me that there was a process. So I will trust that and look forward to us being some of the pilots.
Well, certainly, you know, to the extent you can urge folks to think about being a pilot site and volunteer to do so, I would appreciate your assistance with that as well, at least by way of encouraging it.
Okay, yeah, let me know how I can help.
Ms. Trescott, probably the final question before I show you the last slide and we let folks move on to their hearings or whatever else they've got planned.
Okay, well, I think my question has been answered, but so this is not something that my next custody hearing I can say, I would like an order on visits. I have to wait until we do the pilot stuff, pilot projects.
That's not true. This
Okay.
tool that was presented to you today is for you to use as an advocacy
you said it.
tool. So you may be interested that in the second, and I think I mentioned that at least one, if not all of the judges in the second have utilized this proposed order in some of their hearings. So, you know, this is an order that isn't sacrosanct. This is a tool for you to use, for anyone to use, and to guide your advocacy in family time and in other things as well. I mean, the whole issue raised in the draft order is on planning and being mindful of the specifics of what needs to happen for your kids, for your families, for the whole case, so that we can move closer to permanency, hopefully reunification if we truly are supporting the families. That includes the kids, of course. Any final questions? I think I've asked that several times and I want to make sure I don't leave you without an opportunity.
So I just want to point out Cantrell's response to Sherry in the chat that we are ready in Sandoval County and to do this, and that I think that is, you know, and that's why I was so grateful that you could do this for us, Judge Romero, because even if you're not in a pilot site, even if you're not got a judge who's willing to use the order, that doesn't mean you can't go point by point in your advocacy and ask for every single one of those things to be done when you're talking about family time in any of from the custody hearing forward. So yeah.
Thank you,
So
Leslie. That's really important, and I want to add that, you know, judges in neglect and abuse cases have, as I've already mentioned, a very unique role. Not just in neglect and abuse cases, but in juvenile justice. Very often, you know, what takes place from the bench may be classified as advocacy from the bench. Well, is that a bad thing? But, you know, if no one else is doing it, who will? And if the judge has to be the one that brings up the issue of family time and why don't we have a plan, it's not the best place to start it from, but I would urge judges not to hesitate to do that. Set the expectations. Let folks know what you want done in each of these cases. it works a whole lot better if those who really are in an advocacy role, attorneys, council volunteers, although some would argue that council volunteers aren't supposed to advocate, they have a voice, and very often they're just speaking what they've heard from the kids that they are the eyes and ears of the court for. So I would encourage council volunteers to not be bashful about speaking what's on your mind or including in your report to the court what you have concerns about. That report, of course, goes out to everyone else in the case, so they're not blindsided by what you're thinking about. Mary Ann, go ahead, please.
I'm sorry to keep bugging. So these things keep coming in my brain. So for years it was, visitation, family time is at the discretion of the department. Does that mean, and so for a long time, the judges are, well, that's really the department's purview. So does that mean we can scratch those words off the, I'm just looking at for the balance, because those words are really influential in sort of taking power away from us in terms of the family.
With all due
Clients.
respect to my judicial colleagues, that's a cop-out. Judges need to be actively involved in every aspect of the case plan, family time being one of those things. If we don't look at the affidavit for ex parte custody order before the custody hearing and know what's in that, how do we know how to rule at a custody hearing? What you're presenting today has no nexus to what was in the affidavit for ex parte custody, or even before that. Don't sign the ex parte custody order if the affidavit does not support what they're wanting you to do. You're putting your name and your signature on that. And when you think about the ex parte custody order, contrary to the welfare of the children, that's a tall order that you're giving there. What supports the contrary to the well-being of the child? Are you just rubber stamping that, or have you got evidence on the record? Is there evidence and of course the affidavit is part of the record? Is there evidence, probable cause in the affidavit that supports that finding that it's contrary to the welfare of the child to remain in the home? So yes, Mary Ann, you can scratch that. Be an advocate. I've never
Okay,
known
well,
you to be
yeah.
violent about that.
Well, I've been yelling for years, but I guess my legal terminology isn't persuasive. So anyway, I'm assuming then that order can really be put forth at any time, because sometimes things become more fruitful after the custody hearing in terms of visitation.
Possibly, but I think they become more fruitful if you're prepared to argue from the time your client is and the child is taken into custody.
Okay.
And you met your client and you talk to them about what they want. So
Okay.
early enough in advocacy and contact with your client, whether it's a child, youth, or a parent. So in the interest of time, and make sure Leslie doesn't throw something at me next time I see her, the final slide is just, I want to say thank you. My information is on there. If you would like to discuss further, send me an email, a phone number, and I'll call you back, or just set your question out in the email. We're all working together to make things better. We're not on opposite sides. So let's keep working together and improve the outcomes for children and their families. Thank you all very much. Appreciate it.
Thanks, Judge.
Thank you, everyone. I'm going to sign off.
Thank you, Judge Romero. Have a good rest of your day.
You as well. Thank you.